Hello, everyone. Welcome back to OpenLine. We are talking with attorney Tim Takacs. Not Tim Takacs. He's from Takacs McGinnis. I'm used to talking to Tim Takacs. I'm so sorry.
That's
Chris. Right. We're talking with attorney Chris Johnson. He's with Takacs McGinnis. We've talked to Tim Takacs many times. Chris Johnson joining us via Zoom from their offices up there in Hendersonville, talking about elder law. And I said as we went to break, we're going to talk about wills. How often do you have someone come in and say, what I'm interested in is just getting a will in place for me? And then how does that conversation go?
Yeah, absolutely. We get that fairly routinely because that's what most people think of when estate planning. People come in, there's a lot of people who reach out and they think, well, that's what I'm supposed to do. We see it on television. You know, there's the very formal reading of the will, which really doesn't happen anymore. That's kind of a myth from back in the day. And but people come in and that's all they know, and so that's all they know to ask about. And so what I try and do, and one of the first things in a meeting, I just had a meeting with a lovely couple, and then obviously with their adult child, so it was a great meeting. We had everyone together. And I said, listen, the first about 40 minutes, they had a fairly complex set of issues going on. I said, the first 40 or 45 minutes, we're not even going to talk about your planning. I'm going to give you a quick education on this is where you're at. Here are things that are going to influence your planning factors. Here are going to be options that are on the table. But I just need you to understand kind of how this process flows, what it looks like, where your decision points are going to be, and what are the factors that are going to affect those decisions. And once we've got that, then we were going to dive in and start the planning so that when it comes time for them to make decisions, they are making those as educated decisions, informed decisions. Because, you know, we used to have a saying in the Marine Corps, it doesn't matter whether you go or decide to, you know, turn left or turn right. The important thing is you understand why you're turning left or why you're turning right. The important thing for our clients is in choosing the right plan, they know why they're choosing the right plan. They know I am doing this because it benefits me in this way or benefits my children in this way. So someone who comes in with a will, I'm going to walk them through what the probate process looks like, which is the legal process where you go to probate court, you file a petition to open probate, and you bring the original will. You submit the original will to the court. People are surprised that when you open probate, the statutory requirements of that petition are the name and address of all the heirs, not just the heirs listed in the will, but the heirs at law, which can be different. The heirs at law are the people who would take what we call if you passed intestate without a will, because someone may challenge the will and claim it's invalid, and that means those heirs at law now, they come into play. So you're going to have their names, you're going to have their addresses, and here's a real shocking thing, an estimated value of the probate estate is also required, and all of that is a public record. Most people who think they just need a will, when they hear that and hear that their net worth when they pass is going to be a public record, and the names and addresses of who they want to leave it to are also a public record, they want to avoid that. A lot of people are looking for probate avoidance. I actually had someone say, well, I think I've already avoided probate. I've got a will. And I said, a will is not a way to avoid probate. A will is your ticket into probate. And they just were completely confused. And so that education piece is vitally, vitally important, because if I'm going to ask, there are certain decisions, you can ask any attorney. There are decisions that are attorney decisions, and there are decisions that are client decisions. And especially in our realm, most of our stuff are going to be client decisions. They're going to be, hey, do you want to do this? Because a lot of estate planning really comes down to risk management. I say, hey, do you hear the pros and cons of this route? Here are the pros and cons of this route. But if they're just stabbing in the dark on making these decisions, it's not doing any good. So that probate process, and you know, is that really what you want to do, or do you want to go the trust route? And the trust route is really the route you can do to avoid probate. And a lot of times people say, I want the latter.
Right, they want to avoid probate. Now, see, I've just learned that there's not this dramatic moment where you open up the will. See, I would envision that you sit in that leather chair back there, and the family kind of files in to your office, and then you read it, and one of them is left out, and then there's like this huge fight or whatever. Maybe I've just seen too many movies, but that's...
You've seen a lot of movies.
So it's not like that.
It's not like that anymore. So here's the story is, it was like that at one time, but we are talking many, many, many moons ago. And where that reading of the will, where it really harkens back to, and this may surprise you, is, we're talking 100, 150 years ago, someone had a will. Typically, if the attorney drafted it, the attorney would hold on to the will. Attorneys don't hold on to original wills anymore. That has generally gone away. But back when everyone's homes were made of wood and fire was a real problem and whatnot, typically there were only two institutions that had in the town that had any type of metal vault, any metal safe, and it would be the bank and the attorney. And the attorney could keep all the wills on file there. And then one, the attorney had possession of the will, and two, we didn't have the literacy rate back then that we do now. Now almost everyone can read. They can take a look at the will and get a copy of it and go through it and go, okay, I see that. But before, the attorney might have been one of the few literate people who can actually go through and read it for the family. And so the attorney would sit down and read it, and certainly read the key provisions. But that is a long time ago. It kills me when you still see modern movies. There was a James Garner movie not too long ago. I think it was called The Greatest Gift or something like that, where, he was this baron. I think he was an oil tycoon or something, and he was, there was a dutiful reading of the will, and just like you described, lots of family members were left out and everyone was angry, and you get a chuckle out of it. I've never had the opportunity to do that. I have had it requested that I read the will because there was bad news for at least one individual, and I politely decline. I say, hey, you're the personal representative. And that's part of the duty of the personal representative, is to let the people know, hey, you're an heir in the will, and if someone thinks they're not an heir in the will, they can do that. But no, we don't really have any real emotional, shocking moments or big reveals in the office, and I'm very thankful.
Yeah, you don't want that. All right, that's
no
very
one
interesting.
wants that drama.
What about the other thing that I sometimes think of, I guess? How many of these things are contentious? Is that pretty rare, or is that not so rare?
It's not rare. I can't say that it's common. It does show up from time to time. You will have family members who are receiving a reduced inheritance, or sometimes are left out altogether. Have we fielded an angry phone call, once or twice in the past couple of years? Yeah, I think we have. But I didn't make the decision. I don't. My client did. My client made the decision based upon their life lived and their experience with these family members, and they have every right to do it. I tell almost every single client, certainly when it's prudent to do so, the clients will ask me, clients will ask you amazing things, and one of them is, do you like my distribution plan? And I'll tell them, it doesn't matter whether I like it or not. It matters whether, it's lawful, and I'll make sure that. And but as far as I like it, this is not my money. It's not my money to divvy up. This is not my blood, sweat, and tears that earned this money, that sacrificed over a lifetime, that, provided for these children and knew who needed more help than others. That's you. And so my response to clients is, does it make you happy? When your head hits the pillow at the end of the day and you nod off to sleep, if you were not to wake up tomorrow morning, are the words in that will or in that trust, do they give you peace of mind that you're doing right in your mind? And clients often don't think about it. They're looking for someone else to tell them, hey, is this a good idea or not? And I say, listen, this is your hard work, and you should be the only decider in that. Now, you're happy to solicit from family members or anyone else, but far be it from me to tell you what you should do with your estate. My job is to make sure that whatever you want done with your estate, that the legal documents are in place to make sure that happens.
And how often are challenges successful? Is it pretty hard to challenge and be successful? What about that?
Very rarely. They are exceedingly difficult. There's really two categories of challenges, and so this is a great topic to touch on here real quick. The first one is lack of capacity. The individual didn't know what they were signing at the time. People are always, and we could do a whole show on capacity, and I won't bore the audience with this, but there's different levels of capacity. Capacity for signing contracts is higher than capacity for signing a will. That blows people's minds, but there's a legal reason, and there's a public policy reason. We want people to be able to sign a will on their behalf. We don't want to take that away from them unless they can. And so challenging someone's capacity, you're going to have to bring proof to the court that they literally did not understand what they were signing, didn't understand the ramifications of what they were signing, and they just, someone put this under their nose and they signed it. That's a difficult thing to prove, especially after they've passed away. The second challenge is going to be undue influence. And undue influence is where you've got that caregiver in the home, and all of a sudden they've been in the home for a year or two, and magically now this person who's been there a year is getting the lion's share, if not all of the estate, and all of a sudden the children are left out. That would certainly raise eyebrows, but that alone, just because the facts are not pretty, even that's not enough. You would need to show something that someone leveraged their position to bully them, to scare them into signing these documents, to get them over. It's very difficult to make these challenges. It's not impossible. And I don't want anyone to be dissuaded, because unfortunately in our modern society, there are bad people who try and take advantage of our most vulnerable, and our senior citizens are in a vulnerable category when it comes to that. And you hear people, there was a famous case down in Nashville, I think a year or two ago, where it was the pest control person is going to this house repeatedly and telling them, like, oh, I'm your long lost cousin or something, and got them to make this person their power of attorney. And thankfully it got found out. I believe the person's in jail now, and rightfully so. It's a terrible thing to do. And so if there is a suspicion of that, certainly bring it forth. Just because the probability is low, it doesn't mean it's not worth bringing to the surface. But sadly, those things do happen. And if you have a case, you find an attorney and you bring forth the evidence, and they'll pursue it to the extent that they can. Fascinating.
See, that's all very interesting stuff. Okay, we're going to take a break. Come back, talk about trusts. So let's think about that. There's a number if you want to call, 737+. We will take a break. Be back right after this.